We're live. Welcome to episode 73 of Let's Talk Immigration. Happy Eid to those, or Eid Mubarak to those celebrating. I have a few things to talk about, and then we can go to quick question and answers. Today's going to be a short show, no longer than 25-30 minutes, because I have a ton of work. In fact, if you've been trying to get a hold of me on WhatsApp or Telegram, I'm usually 1 day behind. I'm now 2 to 3 days behind. I will get caught back up, but my first commitment is always to our clients and taking care of their cases. And we have an opportunity right now with most of our clients' cases that are in AP following a motion to dismiss, like AP Mandamus lawsuits where a motion was dismissed. The government filed a motion to dismiss, and the judge hasn't ruled on it yet. And I've got supplemental authority because of this order that was issued last Thursday by Judge Carter in the Central District of California. And I'm circling around to all of our cases in that situation to let the judges in those cases know what this judge did so they could follow that path. Basically, this order on Thursday was pretty exciting. The case is called Lee versus Blinken in the District Court for the Central District in California, Southern Division in Santa Ana. Mr. Lee is an attorney who filed a mandamus lawsuit after attending his H-1B interview in April of 2023. He waited 7 months before filing the mandamus lawsuit. Judge Carter's denied the government's motion to dismiss. And so that lawsuit continues, okay? A lot of times, judges will not sympathize with plaintiffs. I thought it was kind of exciting in that one because a lot of the people who have pending AP mandamus lawsuits that are waiting an answer on a motion to dismiss actually interviewed before Mr. Lee. So I think it's important for our judges to know what's happening there. So that's what I've been working on. That's why I got a little bit behind. Let me go. Who's calling me? No, you can't call me right now. Okay, I'm going to go to the blog from another law firm because that's where I've got some information that I want to share with you. There is a lawsuit that I'm the counsel on called Taharian versus Blinken, originally filed for 14 Iranian families. Some of them already have visas, though, where we're fighting the unreasonable delays in AP, okay? And we were able to get a hold of 2 more declarations in the administrative record in that case. I did not think that we would be able to share these publicly because the government fought for a protective order. But I learned this morning that they did not designate these declarations as being confidential, and so they are not confidential materials, and I can share them. The protective order doesn't apply to them. So here's the big takeaway. I'll make this bigger. Number of DS 5535 cases. It was 59,000 in September. It went up 11% to 66,000 in January. Basically 3 months, right? I was concerned that it was going to go up much more. Of course, right about this time is when we started bringing this attention to all the judges and other attorneys. My colleagues were doing the same thing. And then also, Fox News covered that the AP backlog was 66,000 with only 37 analysts. So all those things maybe going in together has caused a unique, I would say it's good, a development. The AP backlog has gone down 7% since January. As of April 7th, we know that it is 61,000. So that's good news for those in AP. It means that maybe they're finally taking this seriously. Maybe they hired more analysts. I don't know what they did. or maybe just AP Mandamus lawsuits. They've got so many of them that they've decided to start issuing the visas, giving the clearances and issuing the visas, speeding things up because they're getting buried. So what's the other thing I want to share? Present, share screen. USCIS has some news that automatic employment authorization documents extended. They're trying to streamline the way they do their work because they're buried. Okay. If you have more questions about that, you can let us know. In other news, the visa bulletin. Are you an F2A applicant who applied for your spouse to or minor child to join you in the U.S. and you filed that petition after June 1st? No. Before June 1st of 2021, I've got good news. Your spouse and child can finally legally be issued a visa because the visa bulletin is no longer a barrier. So a lot of F2As were waiting to file mandamus lawsuits because they knew it would not be effective while their case was not current in the visa bulletin. Well, your case is current in the visa bulletin. There were some other advancements in this visa bulletin for, is this for June? No, this is May. This is May. Okay. But the big winner is the F2A. I heard like employment. I haven't looked at employment close, but I heard that it was not much change. And then for DVs, there was a little change. If your Africa DV number is under 57,000, you may be eligible for an interview now, except for Algeria, Egypt, and Morocco. Iran still capped at 8,500. Europe still 21,000. Okay, that's the visa bulletin news. Have I shared all the news? I've shared all the news. Now we can jump into questions. Q&A is so much fun. If you have a question and you post it on Facebook or YouTube, it comes up automatically, or even Twitter, it comes up automatically. If you post it on our Telegram or Instagram, I think somebody on my team, one of the little elves, brings it and puts it up here so we see it. So I've been told that this is what's the news. So I've shared the news. If you have questions about the news, let me know. Abby says, happy Eid. Rial says, I have a question regarding the upcoming Gomez class motion to vacate their stay order. Well, that question should probably go to the Gomez class council, as I have been trying to convince thousands of people for multiple years now. I am not Gomez class counsel. I represent Mohammed, Feng Zhang, and Kennedy clients, and also Project Voyager, and good luck and Ray. Okay, but let's go for it. Let's try it. Will the government lawyers inform the DC Court of Appeals that Good Luck Go and Ray are excluded from vacating the stay since the cases are consolidated and awaiting the court's opinion? Well, Raphael has already expressed to the Gomez Class Council that we would like the motion that goes to the circuit court to be inclusive of Good Luck and Ray, but that's going to require some tweaks, and language will need to be slightly different because these cases are procedurally, Ray is procedurally different from Go, and Go is procedurally different from Good Luck. And all three of those cases are procedurally different from the Gomez Class Council, Gomez Class. So to the extent we need to, I mean, we're not going to keep the fact that there's distinctions of secret from the circuit court. The government might make a big deal about it, but I don't think so. The government wants to fight us wholesale. They want to fight the DV 2020s too, and the DV 2021s. Okay, so so I don't think the government's going to make the distinctions. I think we're going to make the distinctions because we don't misrepresent the court. We're going to say, look, there are some nuances here, but everybody is in the same situation in that they're in limbo, and the longer this drags out, the more their injuries accrue in the aggregate and individually. Okay, I hope that helps. Dimitri has a question. What's about good luck? Well, Dimitri, we're still waiting on the outcome of the appeal. But as keyed up by the last question, there's going to be a motion. The first draft of it is being prepared by the Gomez Class Counsel to the Circuit Court, the Appeals Court, to see if we can move things along. Okay, that first draft has not been done yet. It's better it be right than rushed. So nothing new. Okay. AT says, it's been over 60 days and I haven't heard anything for my writ of mandamus for DS 5535 for Montreal. Well, first of all, Montreal is not very relevant to your mandamus when DS 5535 responses are sent via an SAO request to the SAC office in Washington, D.C., and even the consular officer can't even access your application once that has happened. So the embassy part's not relevant. It's very common not to have a positive outcome within 60 days on a mandamus, but you should have heard something. The government has from the time the case is served, the complaint is served, the summons and the complaint are served on the government's U.S. attorney, the civil process clerk, wherever the jurisdiction the case was filed. Government has 60 days to respond under the Federal Rules of Civil Procedure. So if that hasn't happened yet, your attorney needs to be giving a call or an email to that U.S. attorney's office to say, what's up? What's going on? Because there should be a response. Even if it's a motion to dismiss or an answer to the complaint, they can't ignore. And so what may have happened is maybe your attorney did not serve it quickly. Sometimes it takes a couple weeks to serve complaints when people are not on top of it and doing it fast. We try to do it very quickly. Okay, Dildar says, my wife is an AP for 4 months. Okay, after interview, IR1 case. I want to file mandamus. Our priority date, September 2020. Priority date is no longer relevant. The most relevant thing is your interview date. You said it's been 4 months ago. I will tell you, case law will not be on your side. That's the judge-made law from prior cases. However, sometimes the State Department just wants to get rid of a lawsuit. Also, where you file the mandamus lawsuit may influence your specific case, because since it's IR1, in the Ninth Circuit, you have an opportunity to file a viable cause of action under Fifth Amendment due process. We just did 2 of those for IR1s in California this week. But where you file your mandamus lawsuit against the State Department, you have 2 choices generally: where the petitioner lives or the State Department where they live, which is D.C. Okay. Diller says, why they government motion to dismiss? Are they not human? Should I spend thousands of dollars? It's not because they're not human. It's because they want to deter mandamus lawsuits. They want you to post this message on my live so that other people will think, oh, I can't sue the State Department because they're going to file a motion to dismiss. That's basically it. It's deterrence. They're trying to throttle and limit the number of mandamus lawsuits that they face by putting up the least amount of resistance, like a motion to dismiss. Big deal. It's the same motion over and over. They just copy paste it. They've got like 6 data points that they change in it, and half the time they forget to do that, and the name from one case ends up in the next. I mean, same with their declaration. So the reason they do it, it's not because they're not human. It's because they want to deter people from hiring immigration attorneys that do mandamus litigation to challenge their delays. Okay, any news about good luck? As I've discussed before, start over from the beginning. I've already covered that. I heard that if they don't respond, you can get your visa issued. You need to talk to your attorney and don't take everything you hear in a forum as the truth, okay? First of all, what you're saying happened doesn't sound like what happens. I've probably at 150 cases, every 150 cases, you've got the government not responding to a motion to dismiss. By chance, I have one case like that right now. We told them we give them 21 days, so they're going to file the opposition to motion to dismiss, or they clear the case. We don't know within 21 days. But this thing where you get your visa just because they didn't meet their court deadline, no, not true. Okay, thanks for clarifying. Hi, DV 2021, Safi. Don't just say DV 2021 because the majority of DV 2021 selectees, your journeys were over on October 1st, 2021. Those that survive are good luck plaintiffs, go plaintiffs, are DV 2021 selectees who could benefit from the Ray versus Biden order because Judge Chutkan set aside visas for some Schengen area countries mainly. So just DV 2021, you're missing the point. Most DV 2021 journeys are only over. It's just a subset of journeys that continue. Okay, last question. I'm going to end early. I've got lots to do. Dear Mr. Morrison, Urena, LC. My name is not Morrison, Urena, LC. My name is Morrison, Urena, law partner, Rafael Urena. Do you have any hope for Gomez case? Yes. It would be premature to give up the hope. Okay. Let's end early now. So I will see everybody next week for episode 74 of Let's Talk Immigration. Thank you.